Hey everybody, welcome to Estate and Succession Mastery. It's kind of like Where's Wally or Where's Westy today, isn't it?
We never know where you're going to pop up, Mark.
The good thing is you're always in that same spot, Benita. So I can rely on those flowers behind you. Where are they today? You moved them.
They are. They need a bit of water, but they're going all right.
No, that's fine. No, I'm up in Blackall in northwest Queensland, and I think it's 41 degrees. I'm sitting outside my hotel room, and to say it's hot and muggy.
Looking fresh as a daisy.
It's hot and muggy is an understatement. But look, I'm excited about today. Today's your topic, Juanita, and you've got 10 reasons why young healthy people need to get their wills done, as well as what's normally expected is that wills are all about old people getting their stuff sorted. So over for you.
Thanks, Mark. We can hear the lovely sound effects in Blackall in the background, but we'll work with that. We're professionals. We're discussing today. I thought it'd be really interesting to discuss why young and healthy people need wills, because it's not usually something that's high on the priority list for younger people. We'll often hear younger people say, I don't own anything. Why do I need a will? Or we deal with clients that are of the older generation, and they're trying to look after their families, but it can become unravelled if the next generation don't have their own will. And the top 10 tips.
Can I just interrupt? Do you need me to turn my mute on? So
probably
that noise. Okay.
Probably.
I apologise, everyone.
You can jump back in when you have some epiphany of useful information to help us out. So while you're doing that, I'll start off. So look, a number one reason why young people need a will is because they can then choose who will administer their estate when they pass away. So if you don't have a will and you haven't nominated who you wish to be the executor of your will, there is a possibility that someone that you don't want to do it will end up administering. And there's a process that we'll need to go through, those people will need to go through, and a pecking order that the law provides. But basically, if the person that you want is in the top of the pecking order, then bad luck. So, we've spoken a lot about executors before, who the right people are and what sort of person you should put in there. And obviously, number one is someone that you want. So, that's the first thing. So making sure that the person that you want to administer your estate and you trust after you pass away is your executor. The second one that is often not thought of when you go to do a will is that in a will, not only can you leave your estate how you want to, but you can also nominate specific funeral wishes or burial or cremation wishes. So again, probably not something that a lot of young people have turned their mind to, but in the document you don't have to, but you certainly can set out those wishes. And particularly when it comes to matters of cremation, you certainly can't be cremated without your authority. The law provides, but even you might wish to be buried in a particular place, or with your parents, or with a relative on the farm, or this sort of thing. So by specifying that in the will, you're able to lock that in and make sure that your wishes are carried out.
Yeah, can I jump back to number one? I've got all this background noise going on. But when you're talking about executors and so on, Juanita, we've talked in the past about how it's important, I think, to have two, because if you do have children, it's always very important to have one person that's going to be very compassionate in regard to children's needs and so on, but also have someone who's very good from a financial point of view to make sure the money doesn't get wasted and so on. So I've always been a great believer in having two executors. And the point is, with this whole conversation you're having around why do young people need to get this done, is it because for a lot of cases, for young people, once you get it done, there's probably a good chance that they're not going to get it done again for another 10 years, statistically, and from historical anecdotes. So you may as well get it done early and put in place people that you'd want to certainly to be your executors that are going to last for a period of time. So You pick people who are more like your age, I guess, that will sort of age with you. That would be my thoughts.
Yep.
Sorry, and I know you're on number 2, but there was just too much noise.
We can go back. It's all good. Thank you for the input. So we'll go to number 3. And number 3, as I said at the start, a lot of young people say, I don't know anything. But probably the most valuable thing that a lot of young people have is children, right? So in your will, one of the most powerful things that you can do, particularly if you are the parent of a young child, is to nominate who you wish to be the guardian of your children. And along with that, you can certainly put in a separate document, for example, that goes with your will, your wishes as to how you would want your children to be raised. And, even things like where it is your wish that they might go to school, or you want to be able to provide for them with the funds that you leave behind to do X, Y, and Z. Maybe it's a particularly religious wish or the like. But definitely you are able to nominate your guardian or the guardian of your children in your will. I will add that in the circumstance where both biological parents have passed away, the ultimate decision or authority is held by the Family Law Court of Australia. However, putting those wishes in certainly gives a very strong direction as to where you would want your children to go in the unfortunate circumstance if both of you did pass away, or if there was a dispute as to the children. So, certainly very valuable.
And I'm guessing there, Juanita, too, even before you have children, you could pre-nominate in your legal documents that if you were to have children, these are the people that you'd want to look after the children if something went wrong. Would that be fair?
Yeah, absolutely. And just as you can provide, as we often do in your will, if I have children, I'd like to leave my estate to them. If I don't have children, then I will leave it to X, Y, or Z. So certainly there's nothing stopping you putting that in just because you don't have children. If you or you're expecting and you haven't had the child yet, you can certainly still nominate that in your will.
Yeah. I've just caught, as an aside, and I hope this doesn't mess up your list of 10, I had a situation where a son died, and for some reason he'd nominated in his will his girlfriend at the time, and hadn't mentioned his parents at all. When he actually died in a boating accident, he and this girl had been separated for over 12 months. But although she'd been nominated, because she'd been nominated in the will, she ended up being the beneficiary of the will, and the parents received nothing to cover funeral expenses and all the other expenses associated with his accidental death. Any thoughts there in regard to how you'd cover that?
Yeah, and one of the topics I was going to mention a bit later was de facto partners, because a lot of young people may not be married. However, they may be in a relationship or a de facto relationship. And for these purposes, for succession law, for wills and estates, a de facto partner means someone that you have continuously been in a relationship with for 2 years up until or prior to the date of death. Now, being in a relationship with doesn't necessarily mean live with. There's a whole range of criteria which can collectively, when looked at, amount to the fact that you're in a relationship. So the reason this is important is because once you reach that 2-year relationship timeline, then that partner or that de facto partner now does have some rights to your estate if you are to die. And then on the flip is exactly what you just said, Mark. So you might nominate someone and then separate, and that's why we've said many times, if you get divorced, if you separate, then you need to at least look at whether you need to update your enduring power of attorney or your will. But most certainly, it's certainly not unfrequent for young people to reach that 2-year relationship mark. And if they do pass away unexpectedly, then that can really cause complexities and disputes for those left after, potentially. And Mark's totally frozen. He mustn't have liked my answer, but we'll just keep going. So I mentioned, so that's 4, and the 5th topic I wanted to touch on is, as I mentioned at the start of the live stream today, is that we'll often do work for the mother and father, the second, the higher generation of the family, who might have, you know, multiple children, and they'll spend a lot of time, a lot of thought, a lot of investment in getting their estate plan right, which is fantastic. What can undo all of that is if, when they do pass away and leave their estate as planned, if their young person, if their young child, whether they, you know, 20s or 30s, don't have their own will and something happens unexpectedly to them, then all of a sudden all that planning and thought that had been put into the family succession planning and estate planning process comes completely undone. So I suppose if you are a parent listening to this and you're in the process or planning to be in the process of leaving significant wealth to your next generation, one of the questions that you should be asking yourself is, or asking your child, is whether they also have a will. So it's covered if something terrible was to happen to them after you die, that your estate plan, collectively your wishes are carried out, that it goes to control and the assets go to the right person. So we definitely don't want plans being undone because the younger generation of the family don't have their estate planning in place. The sixth point that I wanted to mention is that if you have a will in place and die unexpectedly, if you're a young person, or even, you know, if you don't die unexpectedly, if unfortunately you get some bad news and you know the worst is going to happen eventually, that you decide who you want your assets to go to. And as I said, often people say, well, I don't have any assets. But I'm sure that most young people would be very surprised, because everyone has super, although treated a little differently to being left in your will, which we've discussed on previous live streams if you wanted to have a look at that. But also, sometimes the most significant assets aren't necessarily the ones of the most monetary value. So, for example, often people will have family heirlooms that they might wish to pass down to particular people. So, or, you know, keep within the particular family. We've got Mark back, and you look like you're indoors now. So we're just continuing on, Mark.
I will apologise, but I'm just going to tell you. So here I am in Blackall, and my phone got so hot just sitting outside, it shut down. So my apologies.
Well, that's the first time for everything, isn't it? So we were just saying, Mark, another point of why it is important to have a will for young people is that you get to decide where your assets do go. And you'd be surprised that assets don't necessarily have to be of monetary value. They may be of sentimental value. It might be your grandmother's ring, or you know, a family antique. Now, what happens if you don't have a will and you pass away without a will is that your assets will be distributed as the law says. So you have no say in who gets who. And who that goes to, again, is another pecking order, and entirely depends on your immediate family. So it would go to spouse, including de facto spouse, children, depending on how many children, parents. So there's a formula for every sort of permutation. But I think if I asked anyone, do you want to say who you want your assets to go to, or do you want the law to, they would always say they want to. So, you know, that's a very fundamental reason why young people should have a will, so they can carry out their wishes how they want. The next one we'll go to, we've spoken about kids already, about guardians, but one really useful tool that young parents can have in their wills is the ability to, well, you can never dictate anything from the grave, but I guess a couple of things that are popping up in my head is, one is to create a structure that will protect the estate that you leave behind for your children. So, for example, put in place a testamentary trust to provide all the protections that we've spoken about in previous chats, asset protection, taxation advantages, and protection from mismanagement, and allow you to put in who you would want to control those funds for your children when you pass away. And look, that may be or may not be the same person as the guardian that we spoke about before, but you know, you have the ability to provide the kids with the best structure possible for them going forward, I suppose. And the other really useful thing is that you get to decide at what age they will take their entitlement. So without that provision, the legal age for a beneficiary to take their entitlement is 18. Now, particularly if it's a large estate, I don't think I have, but very small number of people that feel comfortable with their children inheriting directly a large amount, or even controlling a trust directly of a large amount of wealth when they're 18. And I know certainly when I was 18, I don't think I would have been, as responsible as I was, Mark, at 18. I don't think that I would, would have had the life skills to be well equipped enough to manage a large inheritance, for example. So another really good reason is that to put in place a will is you can dictate that age and have some sort of confidence.
Look, absolutely, Juanita. I mean, I look back to when I was 18. Maybe people back then were talking about 21 was an age of maturity. These days, 21 is just still very, very young. 25, 30. In fact, most of the people we deal with now are picking 30, aren't they, as an age? As an age of maturity.
Yeah.
Yeah, 30 to 35. But certainly kids in their 20s, I think these days most aren't married at that age. They haven't had a whole lot of necessary life experiences. They're doing things differently, and I think they've probably matured a little slower than older people did back at that age. So, absolutely. That's something you wouldn't want to happen at age 18 for a child, is to just whack them a whole lot of money in an uncontrolled or a controlled environment and be happy with the outcome for their sake, not just for yours.
That's right, yeah. And look, I have seen someone put in their will 40 plus, which I think is probably a little pushing it a little far, a little unfair. I think by the time you're that age, you're really, you're either going to blow it or not, aren't you? So
pretty much.
you make your own decisions by then. So very useful being able to do that. The next reason why it's a good reason for young people to put in place a will is to avoid disputes as much as possible. You gave us an example before, Mark, where things didn't really pan out, and look, there's always, there's not always. Sometimes there will be the potential for disputes to still rise, and we've spoken about who can contest a will, for example. Not everyone, but can I say, by having a will in place that sets out what your wishes are and putting some structures around that, I think, and bringing people like Mark, you into the planning process and having discussions with the family so everyone knows what your wishes are and what to expect, is the best possible way to avoid disputes. I should probably also add that if you get the appropriate estate planning advice, there are strategies to minimise the risk of a dispute happening after your death, if you are expecting that might happen. So it's all about having that control and putting things in place to avoid that scenario where at all possible.
Absolutely, and a very good point. Thanks, Mel.
You're welcome. Another big one. So let's go on we're up to about number 9 now, I think. And what have we got? We're 20 minutes down. We've got 10 minutes to go. So we've still got plenty to talk about. The next a really good reason from practical experience why a young person should have a will is because it just simply makes the process so much more efficient and quicker and less expensive for the people left behind if you don't have a will. So if you pass away without a will, what will need to happen is that someone will need to apply to the court registry to be appointed your administrator of your estate. Now, there's lots of pecking orders today, isn't there? There is a pecking order for that.
Bit of pecking going on.
Yeah, and so this, if you have a spouse, the spouse would have the priority pecking order, then potentially children. But then what we'll also see is parents being involved for someone that dies young. So, immediately the first dispute could actually happen about who's going to administer that estate. When you get through that process, then the application needs to be made to the court registry, the paperwork filled out. And look, this is going to take about 4 weeks to get all that sort of paperwork and process in and out of the court registry. then that sort of grant of administration needs to be sent to all the asset holders, so the banks, the super trustees, etc., etc. So from experience, the whole process becomes less complicated, certainly more efficient. The funds get to who they should get to quicker, and just less expensive, because all the things I mentioned before will carry costs with them, obviously. So just by putting a simple will in place, at the very least, just a simple will in place, that will avoid all that sort of paperwork and administration for the people that are left behind, which if you're a young person is either probably going to be your spouse or your parents.
So the interesting thing out of all of this, Juanita, is that, we're regularly on a weekly basis dealing with, families with large estates and, complicated structures. And all these families have children. And, those families spend a lot of time and effort in getting their wills done, getting their documentation together to make sure that their wealth passes down to the next generation.
Mm.
And the key to it is also making them that generation, because they're the ones ending up with the wealth, making sure that generation then replicates what mum and dad have done, and created simplicity and certainty and confidence for whatever happens in their future. And as I said before, one good reason by itself in having a will done, even if you're young and you don't think you have any great assets at that point in time, is the fact that the reality is there's a good chance you're not going to do one for a whole lot more time until someone else comes along and reminds you, because we know, statistically, we know from practical experience, unless you actually go and talk to someone about estate and succession planning, they don't just come and knock on your door, do they, and say, hey, I want a will done, or hey, I want my succession plan done. They usually turn up because someone has motivated them. They've had a neighbour who's had a bad experience, the property's been lost in a family squabble or something like that. So the children getting a will done is actually just a sign of respect to mum and dad, knowing that mum and dad are going to make sure they're okay, and they need to get something in place. So whenever they pass away, whether it's soon after they do their will or years later, they have got something that's a legal document which is in place, which is going to provide that certainty, confidence, and security for the people at that stage in their life. They have a care, love, and responsibility for. So it's actually just good manners as well. Did you write that? Was that number 11? Good manners.
Right. To do a will. And as you were talking, something that sort of was coming up in my mind is that if you do the numbers, and I've said a couple of times today already that young people often think, I don't own anything, so I don't need to do a will. But if you're a young couple and you've been working for the best part of a decade perhaps, and you have a young child, so you may have super and life insurance. Now imagine if something happened to both parents unexpectedly in an accident perhaps, then if each of you had a couple hundred, a few hundred in life insurance, in super, then if both of you pass away at the same time, immediately we have over $500,000, which is going to be passed on to the minor child. And that kind of brings in everything we've just said before. Like, do you want your minor child just getting $500,000 in their bank account? No. And, most people don't really think through that, because they think that all I own, I own nothing, or I just own my house, which the bank actually owns, or I've just got my car. But, when you think of that after you pass away with super and life insurance, it can really add up quite quickly. You'd be surprised. Unfortunately, you don't get to use it, but your children can.
No, that's right. And it just comes back to the simple thing. I mean, if one of your children is going to end up with a whole lot of money at age 18, are you actually doing the child a favour, or are you actually prejudicing their opportunity into the future? Because very few children who get a whole lot of money at an early age, very, very rarely something good comes of that. So, it's just wise forward planning and actually respecting your kids as well, and making sure that's one more way you can give them a good start in life and a great opportunity. But I am just going to say before you finish off, and I apologise for disappearing there for a minute, but sitting outside here at Blackwell, as I say, it was so hot, the phone just, what happens when it comes up and says...
Like when it sits in the car for too long and it gets really hot.
No, well, anyway, I had to bring it in and stick it in the fridge for a couple of minutes until it would work again. So that's how hot it is.
Are you in the air conditioning now? Have we got that under control?
Well, I'm in the air conditioning, but I'm going to tell you it's still like 30 degrees. So,
Right. At least you're not in the fridge. That's good.
that's right. But no, you've come up with a really great topic today, Juanita, and thanks for raising this because, as I say, we're doing all our work, spending all our time and effort on making sure mum and dad get this structuring right and making sure mum and dad's wills and enduring powers of attorney, all that sort of stuff is taken care of and all their documents are right and up to date and there's a great succession plan in place. But it's turned to naught if that's then passed down to the next generation and they haven't done the same sort of thing. So, as you know, with our clients, what we try and do is when we're doing everything for mum and dad is to make sure we make the arrangements for the children to get their stuff done at the same time. So, from a practice point of view, that's just a good way to do it.
Yep, that's for sure. Now, my final point before we run out of time, this was a really an interesting one I thought when I was thinking about this topic, which is probably more specific to young people, is that not a lot of people know what happens or what to do with social media accounts after you pass away. So most people of the younger age would have a number, even of the middle age, and I shouldn't be discriminating. So for all people, this applies to everyone, but probably more particular to the younger generation, will have their social media accounts, say their Facebook or their Instagram or their Twitter or their LinkedIn, their Google Drive, etc. So each of those different platforms have different requirements as to how they will handle your account and who they will give authority to manage those accounts after you die. And without going through every single one, it will certainly make things a lot easier for the people that are left behind if there is some direction, A, a will, so at least there's someone that's in charge of your estate to begin with, and then B, even if there's something in the will which gives them the authority to deal with your social media accounts and your passwords of all types, like your online passwords. So something that we're seeing a lot more of, and even putting that sort of thing in enduring powers of attorney is becoming a lot more often. So if you were to lose capacity, then your attorney is able to utilise and have authority to use your passwords for all your online accounts. Obviously some social media platforms prefer to close the account down or turn it into a memorial, or some people just like to get it totally turned off for obvious reasons. So,
Sure.
Something that's really useful.
Sure. What about the ability to vote? Should you put in your will who you want? Because so many dead people are eventually voting these days. Should you put in your will who you want?
Unless you're in the United States of America, then no. No, you're not vote for you. No.
Well, they can't vote. No, but that's actually a very valid point in regard to social media accounts and so on, because it's something that a lot of people don't think about. It's where do I find the password? What happened? And that's a regular thing, isn't it? Like executives going through trying to close down Twitter and Facebook and Instagram and all that sort of stuff. No idea what the account is and how do you go from there.
Yeah.
But anyway, look, you've raised some really good issues today, Juanita. Thank you, because I left this topic all to you today, and
lucky it was my topic. This was your topic. We would have been in trouble when we
would have been in the fridge together. That's right. Anyway, look, great topic. Look forward to catching up with everyone next week, and thanks again, Juanita. Really good.
Thanks, Mike. Happy travels. Thanks, everyone.
Thank you. Hold on. Play. Okay.